All right, everybody. Thanks for joining us tonight. We'll go ahead and start with how to answer the new Fannie Mae and Freddie Mac Surfside Condo Addendums. So this course, if you're a property manager, it has been approved for 2 hours of CMCA credits. Just make sure that you let Fallon know that you intended that you wanted the credits, and we'll make sure that you guys get a certificate for this. But this course is something that it's brand new. I just developed as a result of the new changes that came about on the financing requirements and the challenges that you see a lot of property managers and condominium boards facing, wondering how they make sure that their project is warrantable, how they maintain that moving forward, maintaining property values in their condominium so people can get mortgages and still buy with these recent changes. So we'll go ahead and hop right in. But my name is Kevin Hirzel, so I'm the managing member of Hirzel Law, and I'm going to be giving the presentation tonight. What my goals are is that we're just going to kind of briefly recap what the pre-existing Fannie Mae and Freddie Mac disqualifiers are. So the main reasons, notwithstanding this new Surfside addendum, that we see associations commonly get disqualified. Identify significant deferred maintenance and critical repairs, which is the new thing that's been introduced by this addendum in the new guidelines. And what does constitute deferred maintenance that will disqualify you, and what does not constitute deferred maintenance, and they'll still allow lending in your project. I want to go over what the special assessment requirements are and what they're going to be looking at that. Also take a look at the reserve fund requirements and what their expectation is there. Then the last half of the seminar, I actually want to make this very practical. I've attended a few seminars on this, and it's kind of a lot of general advice, or these are the guidelines. But I do kind of want to walk you through the questionnaire itself and give you some tips on how to answer that, and where there may be some sort of trick questions and what stuff may be kind of straightforward and easy to answer. And then we'll also kind of wrap up with potential liability, if somebody makes a misstep in answering this, and sort of what that looks like. So just as kind of a brief recap before we get into the Surfside addendum, and these requirements, they're still in place. But the primary reasons that I see, at least in my practice, why condominium associations get disqualified or that they can't get lending is that they're over the lending threshold. So basically, you have to have at least 50% owner occupied. If you're, and this threshold has changed over the years. It presently sits at 50%. But before, it was a big thing to get a rental cap when you were in the 25 or 35% range. A lot of communities still want to have a rental cap, but if you let rentals get out of control and they get over 50%, Fannie Mae and Freddie Mac will not purchase loans from banks that lend in your community, which could have a significant impact on the property values. You're essentially looking at cash buyers and people from the non-warrantable mortgage market, which are kind of few and far between. The other thing that they take a look at that would be a disqualifier is if you had any significant litigation. So I've had several associations, they've had major construction defect litigation, or there's a potential large amount of uncertain damages, class action claims, things of that nature, that they will not lend in those types of communities. Depending upon the underwriting standards of each individual lender, some of them will be more lenient. If you just have like a small document inspection claim that's going on, there's no real damages or something, most of the time they will continue to lend within that community. But just be aware that any kind of litigation is still a red flag for the underwriting department of most lenders. And then the other big thing is just making sure that you stay on top of your delinquencies. So no more than 15% of the units can be more than 60 days delinquent. So if you allow the delinquencies to slide and people are not paying, that will also disqualify you as well. So there's a lot of other requirements, but those were just kind of the biggies that I wanted to recap. Now what's going to be new here based on the new Fannie Mae and Freddie Mac requirements is the condition of the building. And so, pretty much prior to the beginning of this year, prior to Surfside, it wasn't something that there was going to be much inquiry into. So both Fannie Mae and Freddie Mac came out with their own lending guidelines. There is a single questionnaire, that we'll go through. And it's my understanding that there's been a lot of pushback, and as a result of this, in 6 or 8 months, there may be future changes coming down the road. But one thing I think you'll notice is that we go through this, that there are subtle differences between Fannie Mae and Freddie Mac. It doesn't appear that it was necessarily a situation where they got together and used the same definitions and came up with the same set of guidelines. And the other thing that we don't have any thing from right now is for VA loans or FHA loans. I anticipate something may be coming down the pike in the future with both of those lending programs, but this is pretty much Fannie Mae and Freddie Mac. And the way it works with them is that they buy most of the traditional loans that you're going to get to buy a condo or a co-op. So the Fannie Mae lender letter, those requirements went into effect on January 1st of this year. It applies to condo or co-op loans with 5+ units. So it's not going to apply to site condominiums or smaller condominiums with less than 5 units. And so, that's the thing to keep in mind. This was really targeted at high rise or units that, there's a lot of attached units in a building. So that's what the Fannie Mae requirements, who they apply to. Freddie Mac has the same requirements. Their guidelines went into effect February 28th. So they've been in effect less than a month, but same type of deal there. You have to have 5+ units, and it has to be in an attached building for the guidelines to apply. So the big thing that they wanted to take a look at with these additional requirements and those guidance letters is significant deferred maintenance. And so Fannie Mae's definition of significant deferred maintenance is that if you've had a full or partial evacuation of your building for 7 days or more, that is a problem that will disqualify you from lending and is significant deferred maintenance, which is fairly obvious. What is a little bit less obvious is some of these subjective criteria that they have down here that also qualify as significant deferred maintenance. So they're going to take a look at the safety, soundness, structural integrity, and habitability of the building. And if you have major issues there, that will disqualify you from or people from getting loans in your project. Substantial repairs and rehab. So they said that's a disqualifier, and then they're looking at anything that's going to impede the safe and sound functioning of major systems in the building. So these are things like your roof, your foundation, structural issues, your electrical system, your plumbing system. And as you'll see, as we kind of get into what is not a disqualifier, they're really looking at building-wide problems as opposed to things that maybe just impact a unit or two. But the major systems of the building is what they're after, and to make sure that there are not major problems there. So what is not significant deferred maintenance? So Fannie Mae kind of gave us a little bit of guidance on this. And so it's routine maintenance or repairs that you're going to undertake to maintain or preserve the integrity and condition of the property. So, things like, painting the building, for example, would not qualify as significant deferred maintenance that would disqualify you. If you had just a routine roof repair that was scheduled, but you didn't have any roof leaks, and just say the useful life of the roof, was up, you wanted to replace it, that's probably not going to qualify as significant deferred maintenance. What they are going to look at, whether there's a problem with significant deferred maintenance, though, is if you have a roof that has a bunch of leaks, you haven't taken care of it, and you have a bunch of problems right now, they're going to view that as significant deferred maintenance, as something that was planned, over time and just as a routine type of repair. As I also indicated, the other thing that they are going to take a look at is whether the issues, whether they impact, 1 or 2 units, or whether they impact a lot of different units. And so if you just had, 1 unit that had a roof leak, for example, that's probably not going to be a disqualifier. But if the whole entire roof needed to be replaced and pretty much every unit on the top floor has a leak, they're going to view that as a major repair. And so that's, I guess, how Fannie Mae opted to define what significant deferred maintenance is and is not. To some extent, there's going to be some subjective calls as to what fits within these definitions by the person answering the questionnaire. So I guess, what are they going to look at to determine whether or not you have significant deferred maintenance or you're okay? So Fannie Mae has said that you're going to need to provide board meeting minutes for the last 6 months as part of your submission. They're going to want to take a look at that. So make sure that, if you're the property manager, if you're on the board, that you have those all compiled, they're ready to go, that you're actually taking meeting minutes. It's required by the Nonprofit Corporation Act, but if you don't have anything to show, that's going to be problematic. And they're really looking through those minutes to see, have there been decisions made, is money being spent on something that would constitute a significant deferred repair. The other thing that they want to see is an inspection report, engineering report, municipal report that happened in the last 5 years. One question, that I've come across is, what happens if we don't have this? And unfortunately, this is going to be a situation that's going to vary from underwriter to underwriter, what they're willing to accept here. Some underwriters, as long as you've submitted the last reserve study, they're okay with this and not having a formal engineering report. Here in Michigan, we don't have required building inspections, so it's unlikely that you would have that, and that kind of thing. So at least what I've seen in practice thus far, the underwriters are okay with just providing a reserve study, even though that is not necessarily the same thing and doesn't look for the same things as full engineering reports. But if you do have full engineering reports or inspection reports or anything from the municipality, they are going to ask you for that and expect that you do provide that going back for at least 5 years. So it's important, if you do have this documentation, to make sure that you gather it up and have it ready to go in the package. So Freddie Mac, they took a little bit different of an approach here. So their key buzzwords or terminology, what they're looking for as disqualifier is what they call a critical repair, as opposed to substantial deferred maintenance. So for critical repairs, what they're really looking at, same type of thing as Fannie Mae, safety, soundness, structural integrity, or habitability. But they added also definitions in here that if any of these things impact unit values or the financial viability or marketability of the project, that would be a disqualifier. So they put that in the guidelines. It's just something to be aware of. I have not seen any questions on the questionnaire thus far. Ask anything about this or expect that you go out and get appraisals or provide that information in order for them to provide loans. But it is one of the differences that was in the guidelines. So it is just something to be aware of, that they're looking at this in terms of dollars and whether there's going to be anything that would lower the value of your property, and that would disqualify you there if you have significant repair issues. Similar to Fannie Mae, they're looking at life safety type of issues, any kind of ordinance violations. They actually use the term significant deferred maintenance and material deficiencies in their definition of what a critical repair is. So they don't have evacuation requirements, but if your building was evacuated, it's probably going to fall into the violations of the ordinances. But this is how Freddie Mac defined a critical repair. And if you do have critical repairs, you would be ineligible for lending within your community. So what is not a critical repair? This one, Freddie Mac really kind of got down into the weeds on. So it's similar to Fannie Mae, and that they basically defined it as if you have something that is expected, so it's within your budget. If you can show them what's in your budget, and that would be a good example, like the roof I gave, that your roof is 20 years old and you decided that you were going to replace it, doesn't necessarily have issues. That is basically going to be an expected repair, so it's not going to qualify for significant deferred maintenance. Oh, sorry about that. They did get kind of in the weeds though. So stuff that is unplanned is, I think, really what they're going to be after, and stuff that, is a nominal cost they don't care about. Where they drew the line is what's a nominal cost or not a nominal cost is $3,000. So that was just kind of arbitrary there, but you can kind of use that as a guidepost that if you have unplanned things that are less than $3,000, they're probably not going to care about it too much. If you have unplanned things that do impact, the whole entire nature of the building, that were not planned for, that do constitute critical repairs, they are going to care about that. And once, again, they're not looking at things that are going to impact one, or as they say, a few units. They're really looking at the overall safety, soundness, structural integrity, or habitability of the building as a whole. So those are the types of issues that they are particularly going to be after. So Freddie Mac, in their guidance, what did they say that they're looking for you to provide? They didn't say a time frame, but they do want homeowners association and cooperative board meeting minutes. So I think, providing the last 6 months is a pretty safe, rule of thumb, and that's consistent with Fannie Mae. They specifically ask for reserve studies, engineering reports. Their information is a little bit more vague. They say they want a list of any kind of necessary repairs. And then they also say any other substantially similar documentation, but don't define necessarily what that is. So, for this one, my advice is not necessarily don't provide a specific list of repairs unless it's requested. You may want to have it ready to go. But, at least what I'm seeing in practice so far is thus far, you can probably just provide a reserve study, and the underwriter is going to be okay with that. If you have anything else, certainly provide it, but you don't necessarily need to go out and get that. And if they're not asking you for this specific list, I don't know that you need to, have a handwritten list ready to go, to provide to them, if they don't ask for it. But it may be a good idea just to prepare this package at the outset, have that as part of the package, and then provide it, if it's requested. So in addition to taking a look at the condition of the building and the repairs, the other big thing that they're going to take a look at is whether you had any special assessments. And really what they're looking for is, did you have any unplanned assessments here? So, in Michigan, most of the time we have what they call additional assessments. And so if there are maintenance and repairs issues that come up during the course of the year, our documents typically define that as an additional assessment, and say the board has the authority to impose an assessment in order to pay for that and gather that money. Special assessment in Michigan is typically defined as something that would be voted on the co-owners. It's not maintenance related. It's going to be like a capital improvement, such as adding a swimming pool if you didn't have a swimming pool before. Sometimes it's buying the unit out of foreclosure. So there's typically a very limited and specific set of items on that. The way that I read these guidelines is, for the purposes of Fannie Mae and Freddie Mac, it's whether you have either a special or additional assessment, they're going to be interested in that. What I think they're really after is how good you are at budgeting and whether you had unforeseen stuff that you did not budget for or anticipate. So just keep that in mind, that it's probably not a good idea to play games with the difference between the technical difference between a special and additional assessment based on what our documents are here. The information that they want to take a look at is basically, if you do have a special or additional assessment, why you have it, how much is it, what are the repayment terms. They're looking at documentation that says that there's going to be no negative impact on the financial stability and marketability of the project. They're also have to investigate whether the borrower is still going to qualify for the loan, even with the special assessment in place. They do indicate in their guidance that if they're unable to determine whether there's no adverse impact, that the project will be ineligible. So if you do have a special or an additional assessment, then you are going to have to make some kind of showing that this isn't going to have a major impact on the project. Freddie Mac, they're pretty similar as far as what they say. They want to know the reason, the total amount assessed, just kind of the basic information, how much is budgeted year to date. They don't say definitively one way or the other whether or not this is going to be an automatic disqualifier for them, like Fannie Mae said. But given that there's one questionnaire and lenders want to comply with both, my advice is try and comply with the strictest standard that they provide. And hopefully in the future, they'll come out with a single uniform standard. But it's the same type of thing, is that, this is, what they're trying to do is encourage community associations to get better at budgeting and not have large additional and special assessments, and not to kick the can down the road, and to have this planned for and perform regular maintenance so major issues don't arise in the future. The last thing that we're going to take a look at before we actually get into the questionnaire itself and running through that is the reserve funding requirements. So in Michigan, you have to have 10% on a non-cumulative basis as the statutory requirement. That may not necessarily satisfy Freddie Mac or Fannie Mae requirements. So they just want to basically take a look, and you'll see in the questions they ask in the documentation, they take a look at that you have 10% in your budget and that you somehow have 10% set aside, somewhere. They basically also, for Freddie Mac, they said this 10% reserve requirement can be waived if you rely on a reserve study completed or updated within the last 36 months, and you submit that to them. Fannie Mae they've suspended those seller flexibility guidelines. They say there's a special exception that you can apply for. In my opinion, the easiest and safest practice to do is just put in 10% and, have that in your budget each year and have that socked away and also set aside. That way you're not going to get into the cumulative versus the non-cumulative debate with them. And you'll just be able to satisfy these lending guidelines as opposed to, potentially having to, submit an exception request to make sure that your association gets on their approved list. Because if you do have disqualifiers, you should be aware that Fannie Mae and Freddie Mac do keep a list of condominiums that are eligible and not eligible. So once you get on their list that you're ineligible, you will have to make a demonstration to them that whatever made you ineligible, that you have, taken care of those issues and move forward. So even though this is a little bit more stringent than what our state requirement is, I recommend, like I said, the easiest thing to do is just have 10% in the budget, so there's no question, and at least 10% in the bank to be able to show them. The tricky part, before we kind of delve into the substantive questions of the questionnaire, is that these forms were provided by Fannie Mae and Freddie Mac. When I called both of their hotlines and asked whether they take a look at this information, they verify it. So the answer is no. So they actually, Fannie Mae and Freddie Mac don't take a look at this themselves. They buy the loans from the banks, and if there's a problem with the loans, then they go back, they get indemnified from the bank, and it's the bank's problems. So the way that they basically said is that it's the underwriting departments of the banks that are responsible for implementing these guidelines. It's the underwriting departments at the bank, that are basically responsible for making sure that, all these requirements are met. And as a result of that, since they ultimately, carry the problem, if there is a problem, they have to deal with that. They give flexibility to all the individual lenders and underwriting departments to interpret their guidelines. And so what that means is that not everybody you're going to see out there is going to use this form questionnaire that Fannie Mae and Freddie Mac came up with. That lenders are free to modify it. They're free to ask additional questions. They're free to ask additional information. So what we're going to go through is kind of the standard questionnaire and what the guidelines suggest. For the most part, I've seen lenders just use that because I think it's easier than coming up with their own. I have seen a few people deviate from it though. And so you just need to be aware that this could be a little bit difficult and that there's not just a one size fits all answer to these questions. And it could vary from bank to bank depending on who the lenders are. You have no obligation as board members or property managers to answer these questions. The downside, though, is that if you don't, there won't be lending in your community. It's going to have an impact on the property value. So I would probably be careful about just doing that and not answering unless you think, for sure that you're not going to qualify and that you may end up on Fannie Mae or Freddie Mac's list of disqualified ones, but I wouldn't just necessarily ignore this because it will have an impact on property values for everybody if people can't get traditional financing in your community. All right, so the questions themselves, I'm just going to kind of walk you through them and tell you my thoughts on them, what they're looking for, and give you some tips on answering them. So the first question is, when was the last building inspection by a licensed architect, licensed engineer, or any other building inspector? So this one, they're really just looking for a date here. It's a straightforward question. It's not intended to be a trick question. Just gather the information and respond. As I indicated, for the most part, they're going to be okay with a reserve study. You should be aware, though, that a reserve study doesn't look at the structure of the building. Typically one of the things that came out of Surfside is that the reserve study specialists have said, we are going to recommend a structural engineer take a look at the building. But they don't take a look at the structure itself. It's mostly the system. So for the most part, the lenders have been okay with getting that in my experience. And so what you'll really want to do is make sure that you have a reserve study or a reserve study that is updated every 36 months is the standard that they had set forth there. And so as long as you have that or an update every 36 months, generally speaking, whenever that was, you can just put in the date here. They're going to want to take a look at that anyways, and you can provide that. So getting a reserve study, it's not only now going to be important for making sure that you're properly budgeting, funding reserves, making sure everything gets done, but it's also going to be important to make sure that your project continues to qualify for financing as well. All right, so question number 2 is the first one that gets a little bit complicated here. And so this one is, did the last inspection have any findings related to the safety, soundness, structural integrity, or habitability of the project's building? Yes or no? If yes, have the recommended repairs be completed? If so, what's not been completed? Then it, ask for, this is where they ask for your meeting minutes and, basically an action plan as to what to do here. So to some extent, this is where they're asking you to make a subjective determination as to whether something constitutes, a critical repair or substantial deferred maintenance is kind of what they're after here, which it's very difficult to answer a subjective question like that. Whether something does impact the soundness, structural integrity, or habitability is a yes or no question. It's also more difficult to answer and if you're not a structural engineer, if you're not somebody who regularly inspects buildings and that's what you're trained in. So it's one thing, if you can walk out, in front of your building and you see a huge hole in the roof and that you have leaks everywhere and that kind of thing. But, the key here, that I'd recommend is that you don't guess, you don't want to speak, basically, I guess, beyond the scope of your expertise is what's really important here. You'll see when we get to the end of this is that there's an additional comment section, and that's where you can reference reports. And really what I would try and do when I'm answering these things is, if you get these reports, when you're talking with the person who's preparing them, make sure that they have an understanding that these reports are going to be used to answer these types of questions. So they prepare the report the way that you need it to be. And really just refer to the report. And I mean, you can check yes or no, but you want to make sure that you qualify that and say, what we know, the information, that we have is attached here. And that's, what we're going to defer to. And that's how we're going to answer the question, as opposed to going out and, I guess, making your best stab at being an engineer or reserve study specialist and, either disqualifying your condominium unnecessarily because you out of abundance of caution, put down that you have all these problems that you may not have, or just, basically saying, the problem isn't that bad, and, checking the wrong box, based on that assessment as well. So this one, like I said, it's kind of a tricky question to answer as a yes or no, because it requires subjective determinations as to whether you meet their guidelines. But, do the best you can in answering yes or no. And then I would also, at the end in the additional comments, tie that back to reports and say, we answered based on this information here, so that they're looking at the same thing that you are, as opposed to you making some kind of a guess. All right, so question number 3 is a little bit complicated as well. It sort of fits in the same vein. As the HOA cooperative corporation aware of any deficiencies related to safety, soundness, structural integrity, or habitability? If yes, what are the deficiencies? And then they're looking at whether the deficiencies have been repaired or not. So once again here, this requires a subjective determination as to whether something affects the overall safety, soundness, structural integrity, habitability of the entire building. You're going to have to kind of go back to the guidelines. If it's just an issue that impacts 1 or 2 units, it's not something that they're going to be overly concerned about there. If you do check the box yes, and you do identify deficiencies, and those deficiencies are not repaired, there's a pretty good chance that your building is not gonna qualify, and that you're gonna be put on that list until you have those things repaired and demonstrate that those repairs can be made. So once again, this is an area where if you don't know, don't guess, just rely on the last report you have. If there's something that's glaringly obvious, that I guess I like to call like the caveman test, like if the caveman walked by your building and could see that there was a very significant problem there, write that kind of stuff down. But if it's just, there's a leak inside the wall in this one unit, you have to be careful about saying that's like a building wide problem, and start making those determinations. So, if you had somebody look at it or prepare a report or a contractor and they just said, this is isolated to a single unit, type of thing, that would be really helpful in keeping you on the list to maintain financing and, protect you if somebody else, comes along and says there's something you should have disclosed on this. Question number 4 is a fairly straightforward one. This one is, are there any outstanding violations of jurisdictional requirements related to safety, soundness, structural integrity, habitability? If yes, provide the notice. So this is really what they're looking for is here is, do you have an outstanding ticket, from the municipality? They're not concerned about things like, is your grass too high? So those types of things you wouldn't need to disclose. They're not related to the structural integrity, habitability of the building, safety issues. If you do have a citation from the municipality, you do have to provide that. One way to maybe, I guess sort of, breeze your way through or to protect yourself is if you can get a letter from the building inspector or the municipality or do a FOIA request. And if it comes up and it shows, hey, there's no issues here, just attach that to your submission, check the box yes, and in additional comments, see a letter from the municipality. And that's probably, going to give your underwriter, warm fuzzies and make you get through the underwriting process a lot more smoothly. It's just one suggestion. Some municipalities may not, give that or do that for you. And as long as you're just not aware of anything, then, that's okay as well. So the next one is kind of tricky. It says, is it anticipated the project will in the future have such violations? And if yes, what is it? For this one, I would just say no, unless you possess personal knowledge that, the building inspector was out and said, I'm going to mail you a ticket on Monday. Otherwise, it's just impossible for you to predict whether 2 years down the road, your building is going to have a problem and answer that. I don't think that's really what they're after here. I think it's just, do you have a known problem presently? And if you don't have a known problem presently and haven't received anything from the building department, I would just check no on this box and move forward. Question number 6 could be a little bit tricky is, does the project have a funding plan for its deferred maintenance components to be repaired or replaced? Once again, what I'm seeing in practice is that a reserve study will go a long way towards satisfying this requirement. So that's certainly super helpful if you do have a reserve study. If you don't have a reserve study, you're probably going to have, issues qualifying for financing. But if you do have some sort of written plan, if you have a plan from an engineer, contractor, anything like that, if you guys decided anything in your board meeting minutes, I would attach that because really what they're looking for is to make sure that you guys have money that is in place to take care of problems in the building. And that's the main thing that they're after with respect to this question. So question 7 is a little bit complicated. Does this project have a schedule for deferred maintenance components to be repaired or replaced? If yes, provide the schedule. So once again, if you have a plan, you got to provide that. Doesn't necessarily mean you have to run out and create this schedule, but be aware that depending on the underwriter, it could cause an issue with you. If you don't have a plan, in the additional comments, you want to provide an explanation and say, hey, we don't have anything that constitutes, deferred maintenance. And that's why we don't have a plan, or the only thing that we have is routine maintenance that we don't think qualifies as a critical repair, substantial deferred maintenance under your definitions. And so we it's okay to tell them that, hey, we keep our building in pretty good shape because we have a plan to do that over time, as opposed to, do we have these outstanding, problems that need to be addressed? So number 8, once again, all roads kind of lead back to the reserve study. As the HOA Cooperative Corporation had a reserve study completed on a project within the past 3 years. So make sure even though it's not statutorily required here in Michigan to do a reserve study, make sure to budget for that, put it in your budgets. As I indicated, they don't include structural inspections. One thing I'm trying to encourage boards to do when they're doing document amendments now is actually in their documents to require boards to get reserve studies every so often or every 3 years and put that in there. So it's something that's in front of everybody. Everybody remembers to do it. It's not, if it's in the documents, then it does not become an optional thing. And it's just kind of, you're forcing yourselves to be in a good position and to properly maintain your community and develop a realistic budget. So question number 9, this is fairly straightforward. So they want to know how much you have in reserve, and then if there's any special assessments, and we kind of went over the difference between the special and additional assessment, but what they're really looking for here is to make sure that you have that 10% in the budget and the 10% in the reserve account. And they're going to ask you for you're going to have to be prepared to paper that. So give them a copy of the budget to show it's there. And you're going to have to be able to show that you actually have that in the bank, and that will satisfy that. So, if you have to do special or additional assessments, you have to do special or additional assessments, because the number one important thing is to maintain your building. You have a duty to do that under your documents anyways. But, to the extent possible, it's better to over budget at the beginning of the year now and maybe have some money left over than it is to under budget for the purposes of qualifying for financing. So number 10, like I said, this could be a little bit complicated. What is the total amount of the special assessments? Here in Michigan, for the most part, we would, use the term additional assessments. They want to know what the terms and what the purpose of it is. And so here, if you have an additional assessment, I would probably put that in there and clarify it in the comment section that, under our documents, this is called an additional assessment. These are the terms of it. We did it this way. It is not called a special assessment under our documents. They've essentially, what they did is just try to use terminology nationwide. And so in other states, they may call it a special assessment versus an additional assessment. But realistically, I think they're kind of after, the same type of thing here. And it's whether you did not anticipate something was going to come up and you had to go to the co-owners and ask them for money. And whether, I guess, in that process, those repairs, have they been completed and have you used your money that way? So question 11 is, are there any planned special assessments that the owners will be obligated to pay? What will be the total amount? What will be the terms and what will be the purpose? So once again, this is an issue that they're going to be taking a look at the meeting minutes. And I know this is something that potential purchasers and realtors get upset about, is that, there's no legal requirement that if somebody is planning an assessment that has to be disclosed. It hasn't been imposed yet. And so sometimes they'll buy in and 6 months later, it will be a shock to them that, there's some assessment that comes down the pike that was planning. So really what they're going to be doing here is digging into your meeting minutes, going back for the 6 months, looking, have you discussed special assessments? If so, they may follow up. They may want additional information from you on that one. So this one is not necessarily that there are ones in effect, but if it's planned versus existing. So if you are planning anything, you should disclose that. If you're not, don't. But anytime they see that kind of discussion in the meeting minutes, that will now raise a red flag for underwriting. So just be aware of that. The other thing to keep in mind about meeting minutes is, I'd say that the vast majority of them that I review probably have way too much information, or more so than is actually required. When you're taking meeting minutes, you really just need basic information that a motion was made about, such and such, and it was, passed, or, was passed unanimously, or the vote was 3-2, or who voted for it. You don't necessarily, you don't have to document what the entire discussion was and who contributed what to the conversation that led up to it. So, just keep that in mind, that when you are taking meeting minutes, that you want to make sure that you keep them, straightforward and simple, and that really what the purpose of them is that you are documenting decisions that are made, as opposed to documenting, the half-hour conversation that you had leading up to the decision. Number 12 is fairly straightforward. So this one, they're basically going to take a look, has the HOA obtained any loans to finance improvements or deferred maintenance, the amount borrowed, terms of repayment. It's interesting because in the lending guidelines, they don't say that getting a community association loan will disqualify your project from lending in the project. At least Fannie Mae has indicated that that's going to be an issue for special and additional assessments. Freddie Mac has not indicated that. So more or less, they just want to know, what I think they're looking at here is this showing up in the financials? Is it accounted for? Is there going to be any unforeseen circumstances? But they do want to make sure, or probably dig deeper to make sure that the work has been done that the loan was obtained for, if it was obtained for repairs. And that's what they're going to be after for this question. And so if you do have a loan, you may want to have the documents ready. I wouldn't necessarily volunteer those right away, but they may actually, ask to take a look into that. So just be prepared when you're kind of gathering your packages and prepping to answer these questions. So the conclusion here is this is the area where they have the additional comments, at the end of the form. Just keep in mind the person who's preparing this, if there's going to be a problem, this is who they're going to look to. And so I know what I see happens a lot of times in these situations is the property manager board member, they'll get a lot of pressure because somebody wants to close on something tomorrow and they need all the information and they want it right away. And they want you just to check some boxes and provide this, but just keep in mind that whoever is filling this out, they're the person that somebody is going to look to, and we'll sort of get into who that somebody is and how you may be able to limit that towards the end. But that's really what they're going to be taking a look at here. So when you're signing this, it's really important not to, go outside the scope of what your knowledge is, and to qualify those yes or no questions that may not be yes or no questions, and really try and tie this back to information that's provided by professionals, as opposed to trying to guess on some of the answers. And if you gather these, this package up, because it's inevitable that you guys are going to have to be responding to this. The first one, it's going to be the hardest time gathering it, but after you do it, once, there's the possibility that you have different lenders in your project and they may have slightly different requirements or requests, but gathering it all the first time is really the most time consuming thing. So the first time you do it, the best advice I can give you is do not rush through this and don't succumb to the pressure of somebody that wants to do a closing right away. And if it, closings across the country are being delayed because this process is way more tedious and there's a lot more information that's requested than had been in the past. So just be careful that if you're the one signing this, don't be in a hurry to do it. For the additional comments section, what we typically recommend is that you put a disclaimer in there, whoever's signing it related to your knowledge, that you are not an expert, you're not an engineer, that you are providing this based on the knowledge that you have relied on the advice of experts in preparing this. So, it's very clear if there were to be a problem and somebody were to come back on that you made that qualification. Qualify the yes or no answers. You don't just have to give into the form and check the box yes or no. Make sure that you're qualifying it where appropriate. Typically, we've for a lot of these people, we don't necessarily have to review every single one that comes in, but your initial package that you put together, it's not a bad idea to have an attorney just take a look at that, spend an hour or two, making sure that you have the appropriate disclaimers, qualifiers, that you're not really seeing anything to get you into trouble or guessing, or to help you if you have sort of borderline issues about whether something is interpreting the guidelines as far as substantial deferred maintenance or critical repairs. would certainly be helpful. And you guys as board members, if you're relying on the advice of attorneys, that gives you liability protections under the Michigan Nonprofit Corporation Act as well, as opposed to just, trying to guess and put that out there. So, and like I said, don't guess. It's real easy to want to be helpful and to volunteer information, but it's really important, especially in answering these, to stay in your lane here. So, so the potential liability issues that could come out of this that you'll want to be thinking about is, Fannie Mae and Freddie Mac versus the lenders. I touched on this a little bit earlier. The lenders, basically they're going to owe Freddie Mac or Fannie Mae if something goes wrong with these loans, or if the building were to, just collapse or something along those lines. Fannie Mae and Freddie Mac themselves don't check for compliance. And so, basically you would be on the hook, potentially for the representations that were made to the lender themselves. This is not necessarily a situation where I think that the federal government or anybody is going to start prosecuting a bunch of people for mortgage fraud based on these disclosures, especially since they're complicated. And it's the best way I can maybe describe it. It's kind of akin to marijuana under federal law, is that it is illegal. But they don't go, basically prosecuting somebody for lighting up a joint. There's going to have to be a big problem, and so it's not necessarily easy to answer this, but as long as you're making good faith efforts, the only way you're probably really going to get into trouble is if you're intentionally not disclosing information that you know about, or just outright, lying on the form there in a mortgage fraud situation. But just keep in mind, Surfside was kind of a good example that when something went really wrong, they pointed the finger at everybody. And so that's why it's important to be careful on this. The other things that you are going to want to, do, or people that could potentially make an issue out of this, is third-party purchasers or realtors. And so in that additional comment section, I'd recommend, saying that this is only for the purposes of lending and it can only be relied on, by that particular mortgage company or bank or whoever is doing the lending there. Because you don't want to set up that a third-party purchaser or a realtor somehow got their hands on this and then they relied on that and then they sued you based on these representations, when you don't have any legal obligation to make a representation to them as the board, or as the property manager. And so you can limit who's entitled to rely on that. And if they were to bring some type of claim against you, you can say, look, this was limited only to allow the bank or the mortgage company to rely on it. We expressly put in here that you weren't entitled to rely on this. And so whatever claim that you're trying to bring for fraud, or that we reasonably relied on this form, that has been expressly disclaimed in the form. And that's also true, for co-owners as well, if there's some kind of, issues or something like that. And so you really want to make sure that you're limiting the scope when you're turning this in, as to who has the ability to reasonably rely on that, and when reliance is warranted. And if you just turned it in as is, you could, essentially open that up to a broader scope of people and have a greater potential exposure there for liability. So I'll go ahead and stop the presentation now. I'm happy to unmute everybody if you guys would like to ask me any questions about the presentation, but hopefully that will at least give you guys some tips and some things to think about as you're going through and answering these individual questions on the questionnaire. So if there's any questions for anybody, go ahead and unmute yourself, and I'm happy to answer them.